Hey, welcome to today's show. We got Rich Goldstein from just outside the city. You know, my good friend Lai Sun always taught me that it's just the city. You know, one of the things that fascinates me about Rich, not the lawyer aspect, but the IP and patent aspect, and I'm fascinated by that world. And Rich, I can't wait to talk to you more about that and understand more about it.
Sounds great.
So what got you into, you know, that? I mean, because I have several friends who are business lawyers and do various aspects, but what drew you into the whole patent world?
Otis, it was a combination of things. I mean, first of all, I was studying electrical engineering, and so I was on that path. I've always been very technical, always been interested in how things work from a very young age, and you know, interested in ideas and developing ideas. And I think that's what led me to engineering. Went to a pre-engineering high school, went to college for electrical engineering. While I was there, I got into entrepreneurship. I got into business, and I found out that being an engineer wouldn't mean working on something cool every day. It would mean working on the same project day in, day out, maybe for 5 years at a time. And so I decided that wasn't going to be enough for me, and I considered changing my major to business and pursuing entrepreneurship. Then I learned about patent law, where you need to be an engineer or a scientist and a lawyer in order to practice. And so I finished up electrical engineering, went on to law school, opened my practice, and now I work on something different every single day.
Man, that must well, first off, I have to know, were you a tinkerer growing up? Because most engineers I know were, to include me, were tinkerers.
If you call, you know, taking every piece of electrical equipment in the house apart with a screwdriver from the age of 3, then I guess I was a tinkerer.
Yes, I have fond memories of my very first clock radio being spread out all over the floor and never being able to get it back together again.
Uh-huh.
Oh, that's great. And you know, that pursuit of something new can be exciting. And what is it that you know, that drives you the area? Is there a certain focus area that really excites you, or what within the patent, I guess is?
Yeah, within the patent realm, I mean, I like working with entrepreneurs. I mean, that's what excites me. I don't really like corporate type work. There's a bunch of reasons for that, but really what I do enjoy is just working with people who have a vision of what they're looking to create, and then working directly with them to help them from the IP side of things, help them from an IP standpoint, to help them to fulfill on that vision.
Well, where does that start? You know, because I'm like most folks, you know, got the garage sort of things, and you know, a couple of other little ideas that I've even drawn out. When do you start to say, all right, I need to protect this? When does that happen?
I think at the earliest moment at which you realize that you have something valuable. So, in the beginning, you are likely searching for a solution. You've identified a problem, and that's too early a stage.
Mhm.
Maybe then you begin to identify a solution, but you know, you kind of know a general direction in which you're going to be headed with this, but that's probably, again, still too early. But once you have the idea, once you have the idea where the idea itself is something unexpected, it itself is something that's potentially valuable, that's when you ought to consider protection. So I was talking with someone the other day about this, and maybe as an example, so you say, I want to come up with a better cleaning product. You know, I want to, you know, I want to have a cleaning product that's non-toxic, that if a child ingested it, they would not be harmed. Okay, well, that's an aspiration. You've identified a problem and you have a direction towards a solution. That's too early to think of protection. You've simply identified a problem, and a potential direction, then maybe you say, so what I think I want is to find something that's maybe plant-based. If I found something that's plant-based, and edible, then I know that it's something that wouldn't be harmful. Cool. That's the direction of a solution, but still too early. You can't protect the idea of having a cleaning product that's plant-based and edible. But then maybe through some experimentation, you discover that a certain plant extract actually breaks down grease. And you look around and you don't see any mention of this. You don't see anyone else having ever talked about this plant extract being useful to break down grease. So this is maybe the earliest instance of you having something that's potentially valuable. That discovery. You haven't yet figured out, well, how do I extract it? You might not have figured out in what proportions, in what amount of ingredient you'd need to use in a solution. Is there something you need to add to stabilize it, or any of those other details? But perhaps, that notion of using that plant extract, that's novel. That's something that people haven't thought of before. Then that's potentially valuable. That might be the time then to consider getting some initial protection for just that notion.
What was popping into my head in my simple way of defining it, or kind of drawing a line, it's not necessarily I have to have the actual widget,
Right.
or even the engineering drawings of the widget. I can have the idea for the widget that is unique, right?
Yes, exactly. As long as the idea itself is unique, the idea that you have to date is unique, then it's something we can pursue. But if kind of what you've had in mind is what people have already thought of, then that's not something that you don't yet have enough to pursue. So it's kind of like once you've thought of something that is itself unique, that's when you could pursue it, even if you haven't worked out the details. You don't have to have engineering drawings. You don't have to have all the details figured out if the concept in itself is unique.
Okay. And then, so that protects you from somebody else stumbling across it, or is it more, a friend of mine was telling me a while back, I think it was something along the lines of first, you get your first in the door or something like that. Is it kind of what that is really?
Yeah, well, and that's the thing. You have to take the right steps in order to protect it. I think the concept I'm pointing to is you could protect as broad an idea as doesn't already exist. If a fidget spinner didn't exist, you could perhaps protect the concept of a fidget spinner, right? But if it did exist, then maybe it's a matter of having more of the details about how yours would operate. It's got 3 spinning items which are on a central axis. Then you're digging deeper into kind of what the solution is. So, but that's this is really important. This concept right here of how something gets protected, because a lot of times people have one of two notions about patents. People will say, well, patents are so important. If you have a product, you absolutely need to get a patent. And then there are other people that say, well, patents kind of a waste of time, because if someone just changes one little thing, they get around your patent. And now, two opposite schools of thought, which of them are correct? And the answer is really that they're both correct at different times. There are some patents that are broad and cover a whole concept. And there are some patents that are very specific, just for the details, and they're not very valuable. And what it comes down to is the difference is, did you invent a whole new concept, or did you just really invent the minutia? Well, there are lots of things like it, but you just invented the very, very specific aspect of it. And then it's not really that valuable. You might be able to get a patent, but it's going to be a very specific patent. So, I think that that's an important thing to get out there, just in terms of what I'm saying, and of like, when is the right time? It kind of depends whether you have a big idea that's new, or the big idea actually exists, and it's more the smaller idea that you need to refine to get to. And then, just to answer your question, we are in a first to file system. So the first person to file the patent application is the one entitled to the invention. And so you need to file a patent application of some type in order to establish your priority. And it has to be one that expresses your idea properly. Just filing an application that you throw together and send into the patent office isn't going to protect your priority. It has to be something that really embraces the concept. And then if you're first to file, then you're the one that's entitled to the patent.
Isn't that part of the legend of Thomas Edison and Nikola Tesla? That supposedly the paperwork and the shuffle, isn't that part of that legend?
Yeah, I'm not sure about that one. I mean, there's a lot of interesting things about the Tesla and Edison saga. It's kind of about how, you know, like they each dug their heels in different types of technology. It's like, well, you know, and then they had a battle over who really owned, like who really was going to own the future, essentially, through it. I think that's the story with Bell and the telephone of that it was a matter of who got to the patent office first. I believe, as the story goes, they got there on the same day, but one got there, you know, earlier in the day, or it got on the stack of papers earlier, or something like that. But it was a matter of who filed their application before the other.
Yeah, that's the thing that legends are made out of, right? Well, what is your favorite one so far? I mean, you've done hundreds, right? I mean, we're in the probably lost count how many you've done. So what's the favorite one that sticks with you?
Oh wow, that's hard. I mean, I've done thousands, and then there are ones which are interesting for different reasons. You know, there are ones. Well, I mean, I think one of the funniest or most fun ones was it was a condom in a nut novelty. So I had this older gentleman. You know, he was way up in his 70s that came into my office, and he sat down with me to show me his invention. He handed me he handed me a walnut, and he handed me a nutcracker. And I said, well, what's the invention? Is it the nutcracker? And he said, no. He said, just go ahead and crack the nut. So I cracked the nut. The pieces of the walnut disintegrated, and sitting in my palm was a condom. I'm like, what?
Unknown caller.
I'm sorry. I'm going to have to tell.
You're muted.
Sorry, you keep calling me. I guess you'll edit this part out,
Yeah.
right? Yeah. Okay. Yeah, it's just you know, he called my desk phone, my cell phone twice, so I had to let him know.
Yeah. So back into the nutcracker condom.
Yeah. Okay. So I cracked the walnut, and then the pieces of the walnut disintegrated, and suddenly sitting in the palm of my hand was a condom. And I was like, what? You know, he's like, that's it. It's a joke. You go into someone's house, and they've got a tray of, you pass them a tray of nuts, they pick it up, they crack it, and then suddenly they've got this condom in their hand. And I'm like, oh, okay. And he's like, I have a special process for getting it into an actual walnut, so that it looks natural, and you've got this gag item. Like, okay, cool. And so and I was like, and what do you want to do with this? Like, it's like, I just want to do it for fun. Okay. And you know, and it was kind of neat because so we got him the patent on it. We got him a patent on basically a condom within a walnut, as a gag, as a novelty item. And you know, interesting thing about it too, just the human part too, is like he was much older than me. I was in my 20s at the time, and he was way up in his 70s. And and he used to say, you know, I never had a son, but if I did, I would have hoped he would be like you. And then when we talk, he'd call me son,
Oh,
you know, and you know, when he passed, you know, when he passed away, uh you know, I definitely felt it and remember it. And so if you know, ask me about like a favorite, that's one of the reasons why I label as a favorite, because it was fun. He did just for the heck of it. Like there was no real reason to get this patent, except he wanted to have a patent and he had a fun idea. And but yeah, so that's my favorite.
that's a great one. It reminds me back to what was that old that store in the mall? All the shopping malls had, it was like Spencer's Gifts or something like that. I'm sure that was probably his number one customer was Spencer's Gifts, if I remember the name. I just remember there was always black light things and weird posters in that, and they always had those novelty gifts. So yeah.
Yeah,
Well,
absolutely. You know, actually, I just want to finish that story too. Is
oh
like
yeah.
I'm saying, when he passed away, his family called, and it's not that we had any more business going on anymore, but they said that we just want to let you know that he passed because you meant a lot to him, and that's great because you don't typically call your lawyer, or family won't call your lawyer unless it's about probate or something to
Yeah.
let them know. But apparently, apparently it had an impact on him that he followed through on that dream of getting a patent, even if it wasn't something that he monetized.
That's cool. Yeah. I mean, I could see that vision for, you know, in your life of, you know, almost like a bucket list sort of thing. I just
Yeah,
want to get, you know, get a
and he
patent.
did it.
Yeah. That's really cool. You've been doing this for 25, 30 years. And what I'd love to learn more about is how you turn this into a business, how you went from, you know, somebody coming into your office with a walnut in
Right.
their hand to actually it's now a business. How did you kind of make that adjustment?
Oh, well, I mean, it's interesting because I started my law firm right out of law school, and that's extremely unusual. I mean, typically the path. I mean, in any business, like you need to be able to provide a product. That's A, but even more importantly than A is you need customers, right? And so, typically when people start a law firm, they already have customers. They've already been working somewhere. They've created some relationships, so that when they leave the firm to start their own, they already have some business. I started without any business, and kind of the way that I started was by launching a magazine with a friend, a magazine for inventors, and so it's like I launched a magazine that talked about inventing and patenting, and I had an advertisement for my law firm in the magazine. So essentially, I was doing what we now call content marketing, but back in the 90s and in print form, not on the internet. So pre-internet, I was doing content marketing by putting out these magazines and kind of creating interest in inventing and pursuing inventions and a pathway for people, and then also generating leads. So that was really the way in which I got started. And also, I began to build my business through Yellow Pages. Again, like I'm sure that not everyone who's listening can relate to Yellow Pages, but I had the biggest ad on the patent attorneys in Yellow Page books in New York and California, and I opened up offices in Los Angeles, San Francisco, and New York. And I used to once a month travel around from office to office, meeting with clients, and that's how we got to do lots of patents. I mean, we've obtained over 2,000 patents to date, and have worked with tens of thousands of people in various capacities.
What was that first thing that, as you grew to the business side of it? I mean, this is an interesting field because, you know, I always talk with clients and other folks that I mentor in the aspect of working, you know, on your business, not in your business. But from what I'm hearing from you, you still, you know, you got to have that get in there and see that new widget. But in that aspect of scaling, what was that first thing that you took the step and realization that become, a CEO and not a solopreneur?
Oh, okay. Yeah, that's actually and like put it this way, I was in business for a while before I took this step. I mean, this is let's see, around 2011 actually. So this was a good 13 no, I'm doing my math incorrectly here. That's about
Public math
17,
is dangerous.
17 years in. 17
Yeah.
years into my practice is when that really happened. And that was, I actually was working with a consultant, and looking at the things that would make a difference with my business. Like what are I did a $10,000 consulting day with this person, former McKinsey consulting person who's just really great at scaling businesses. And we sat down, and the couple of things we decided to do was to get me off of the phone, to not do consultations with people that haven't already become a customer. And so really it was getting myself off of the phone, and having other people, explore opportunities with clients. And when a client decided, yes, I want to go ahead and do your patent evaluation, then they would pay, they'd become a client, and then I'd have my first conversation with them to begin exploring how we can help and what we can do, and kind of what the best way was to get them IP for their concept, for their business. So that was the most important innovation. And just if you're wondering, like, what was the second thing, because you said a couple of things, the second thing was to then take some steps to build credibility, so that essentially the evaluation could be sold without me being on the phone, being the one selling it. So I created a series of videos, a series of 6 videos, that have been watched tens of thousands of times, that just explain the process. And then when clients sat down with me from that point on, by and large, they would say, I watched the videos, I love the videos. And after I watched them, I didn't want to work with anyone else. It's like, I realized that you're like me, you're like my type of person. And, something that they related to me, and they knew they wanted to work with me. So that was the other thing that Victor had me do. I'll give him a shout out, Victor Cheng, really brilliant man. He's an expert in scaling businesses from 1 million to 25 million. So those are the 2 things that Victor had me do: get myself off the phone, and then take steps to build the credibility through educating my customers by creating those videos.
And how long before you were comfortable with that? Do you remember?
Oh, it was pretty immediate.
Really?
Wow.
Wow.
Yeah, no, it was definitely pretty immediate. And then kind of further from there was adding other attorneys, and not necessarily even being the one that is working directly with the client, having other people on my team. So that was another step in that, a part of the evolution. But yeah, I guess to answer your question, it wasn't long before I was hiring other attorneys. So it was pretty quick that it took hold, it made sense, and it made me scalable, because I can't, I get about 250 inquiries a month from people that are potentially looking to do a patent. I can't talk with all of them. I'd be on the phone all day and have no time to do work. So essentially, it was necessary to set up systems to to explore with people whether it's a match to work together, to explore with people whether they were ready to invest, to have me involved in their project, to figure it out for them.
So then what's the filter now? Because if you're still doing them, right? You're not just running the show. You still have that passion to get in there and see what that innovation is and then put it together, right? So
Yeah.
how do you filter that other people do it, vice you or whatever?
Yeah, exactly. I have other people that do it. You know, I on my team, I have people they'll have a conversation with someone who's potentially looking to do a patent and explain how it works. You know, explore with them what they're trying to achieve, and then find where there's a match between what they're looking for and what we can deliver. And then, you know, if it's appropriate, then get them started, grease the chute towards making it happen.
Mhm. But how do you know which ones that you get involved in?
Oh, well, I mean, essentially it's the ones that oh, you mean me personally?
Yeah, you personally. Yeah, that's what, because without getting bogged down in that whole mess. Well, not mess. I know it's not a mess, but yeah.
Yeah. No, and I think you're pointing to an important challenge in scaling too.
Mhm.
I mean, you know, ultimately it would be great for me to not be involved in any of them, right? And maybe in a number of years that's how it might be. In the meantime, it gets divided up by a few things, including some people just insist on working with me directly, and we honor that. And then also some projects according to the different expertise and what they're looking for. And for example, also if it's trademarks that they're looking for, then that's one of my associates who you know, truly knows more than I do about trademarks, and so he is just the absolutely the appropriate person to handle that. So the trademarks get put in his direction, and then with regard to the patents, I think we figure out whether it's something which again, someone that really wants to work with me, someone that I know personally a lot of times that I've met. I attend a lot of events. I attend a lot of events, and I'm very social, and so I get a lot of inquiries through my network, and so a lot of times I end up working with those people directly, and but but yeah, and a lot of times too, um, I work with clients and kind of triage the situation enough to really figure out how to steer the ship. And then it may be that my colleagues are doing a lot of the heavy lifting on the project, but I get involved to figure out what needs to be done and to make sure that it gets done, even if I'm not the one spending 30 hours writing the patent application.
Yeah, I think that's one. I've flipped through a couple over the years, and folks, if you haven't pulled up and just Googled a patent application or one that's been, you know, approved, it's really quite a span, because there's the super simple ones, right, that are like one page, and then there's the, you know, 2-inch thick ones that explain all the details. So that's
Yeah. Well, really, the difference there typically is that the one pagers are usually design patents.
mm,
So typically, a design patent is just protecting the look of a product, just the physical appearance. So the critical thing there is the drawings, is having it correctly show the design from every angle. There's some very strict rules about how the patent office wants that presented to be 100% consistent between the various views. But there's not a lot of writing because it really is all about the drawings. But then on the other hand, there's utility patent. And utility patent is what we typically think of when we're thinking of an invention. Like, we've come up with an improvement. We sat in our garage and we tinkered to find a better way to make something work. So what we arrived at was something that was structurally different for a functional purpose. That's what a patent is all about. It's about that functional difference in a product, or in software too. Software is protectable by utility patents. And those are the ones which are extremely lengthy, because we have to go into a lot of detail to show what the invention is, how it's different from things that have been done before, and really why it's worthy of a patent. I mean, it sets the stage for the examiner at the patent office who's going to review it to begin to see it favorably, see that it's different, see that it's worthy of a patent. And so it's, you know, utility patents are involved, and they're expensive because they're time consuming to put together. But yeah, absolutely. But that's what needs to be done in order to apply, in order to put your put yourself into the game toward getting a patent.
Do you have a patent? With all these patents that you've reviewed and written up, do you have one? Come
I
on.
don't. I don't.
Oh,
You know, and it's not a fantastic story, because like it's not like a triumphant story, but actually before I became a patent attorney, I actually attempted to apply for two, and I was turned down on both of them, and I didn't get them through, but they were.
what were they? What were they, Rich?
Okay, well, one of them I thought was a very interesting idea at its time, but we went in a different direction. So I think in the early '90s, they were beginning to experiment with toll taking systems. Like, in other words, when you go over toll bridge, automated toll taking systems where you had a big barcode sticker on the car. And so I saw a number of cars with these barcode stickers, and I was like, wow, that's really ugly. And then I thought about an idea of a machine readable sticker, like one where the pattern is invisible but shows up under UV light. So that's why I attempted to apply for a patent on. And it turns out that there was other prior art. There are other types of machine readable stickers that, in essence, I didn't get the patent. But interesting lesson there is that wasn't even the direction that the technology went. The technology went towards these radio transponders like Easy Pass or Sun Pass, or in different places they have different variations of it, but a little radio transponder that sits in your windshield, and then when you drive through, it reads the transponder. So the idea I had actually didn't turn out to be useful, even if I did get a patent. And the other one was, in the early days of cell phones, I had this idea that, well, I mean, I actually had a cell phone in 1989 while I was in college. It was this big cell phone. I don't know why I needed it, but I thought I was an entrepreneur and I thought I needed a cell phone. It's that back when you paid $1 a minute, to talk on the cell phone. And I, if the phone rang in class, I was like, I kind of like, try to quietly leave and then like pick up the phone, but I might often miss the call because it just took too long. So I had a notion that on a cell phone, you would have a button that would let you silently answer the phone, so that if the phone rang, you can press the button and it would tell the other person to hold on while you walked out of the room, and then could actually start talking. And this was before voicemail on cell phones. And then the fallback to that was that if you didn't, you could also press a button to have it then take a message like voicemail. So that patent application again was rejected because they found some hospital paging systems that had to do with like paging a doctor and then putting the person on hold, and then they could pick up an extension in the hospital and then dial into the call. And not that it was identical, but, and this is an important lesson here too. One of the standards for getting a patent is that it has to be non-obvious, which means even if an identical thing to it doesn't exist, if something close exists and they could say that whatever you've done that's different kind of falls within the range of what other people would think to do, even though they haven't done exactly that. They call that obvious. And so they said, well, it was obvious in light of this hospital paging system. And it was really early. I mean, I wasn't even yet a patent lawyer. I was just learning about patents. I didn't fight back very hard, but in a certain respect, looking back on it, I kind of invented, send your call to voicemail on a cell phone back in like 1992, I think. So that could have been something that's valuable, but I didn't really know the process, and I didn't have someone that was skilled to really help me navigate it.
Oh yeah, yeah. Well, and that's, I think that's part of the benefit of working with somebody like you on your patents, as opposed to, because of course I could go online and I could do it myself as
Right.
as a just a, a regular Joe.
Right.
But to get that expertise in the right wording, and then if they push back on it, how do you reply back? That's where
Exactly.
somebody like you really comes in.
How it's written makes all the difference in the world, because I know of cases where like the difference between someone buying a patent and not buying a patent was just one word. Like,
Hmm.
and think of one in particular where they considered not buying the patent because of there was one word that had them say, well, maybe we don't need this. Ultimately, they did then decide to buy it. But if if they decided differently about that one word, it wasn't a matter of, well, okay, now the patent is worth half as much or a quarter as much. It's like it's worthless, right? If there's a clear path toward making the product without the patent, then no one needs it, no one wants it. So how a patent is written is not just important; it's really everything.
That's great. What's next in the patent world with your business? What's happening next?
Oh, okay. What's happening next? I mean, I think in terms of the field itself, what's happening next is what the field is all about, right? It's like
Mm,
patents are all about whatever is next, and whatever is next, we find a way to protect it, and I think that's what makes it fun, right? It was that famous patent office director from the 19th century that said everything's already been invented, and I guess at any given moment we might say like, well, yeah, it just seems technology's come so far. What else could there be? Well, until that thing exists,
yeah.
and almost by definition, for something to be patentable, it has to be non-obvious, something which another way of looking at it is saying, I wouldn't have thought of that. Like it's not a natural progression. There's some type of cleverness that's not just expected. So I guess what's next, it's not obvious.
Ah, oh man, that's like the classic answer. It depends, right?
Mhm.
Just from the patent lawyer's point of view, it's
Yeah,
non.
like if we knew what was coming next, then it wouldn't be patentable because it's the expected progression.
There you go. Job security, Rich. That's what that is.
Yeah, well, I mean, but it's also uh, it is, and it's also a good lesson in that not everything is patentable, and it's like, so for example, people, um, let's say when the MP3 player came out, and someone said like, oh, I had that idea 20 years ago to have a device where you had you were able to store lots of songs on a memory device and not on um, and not on a compact disc or not on some a cassette tape or some other type of medium. It's like I had that idea, yeah, but when the actual MP3 player came out, it was obvious. I mean, it's not something you could patent because the thing is that people always knew, and people have known for as long as computer memory has been around, that you could store sound waves on memory. You do something called sampling, where you kind of take take like 40,000 or so snapshots a second of the sound waveform, and then you could store it in memory. You could reproduce it. That was well known. The only thing that was missing was that memory was just way too expensive. When I graduated law school in 1994, computer memory was $50 per megabyte, not gigabyte, but per megabyte. So it would be like $50 of memory to store, even compressed, maybe 3 songs. That doesn't work. So basically the natural progression was that memory became cheaper and it became feasible to do it. So people have always known that they could make a device like that. It's just the time wasn't right yet. Like the pricing wasn't right yet. And so that's, I think, something for anyone who's innovating who needs to consider, is that not every invention is patentable. If it's kind of the natural progression, it's not going to be patentable. And so then truly, it's like, what is coming next? It's not obvious. And if it was obvious, it wouldn't be patentable.
That's great. That's great. So I'm at that point of the show where, usually I make some snide comment about Camden and the what we learn, the father son, just I got to make sure I keep my son in his place, right? But for me, I think the most obvious thing I learned was the non-obvious. Man, we're having some fun with that word today. Lots of dad jokes going on with that.
I have lots of fun with that word every single day.
Oh, I bet.
Sometimes not so much fun.
Yeah, for the person that presents it to you, there's probably a big letdown that it wasn't.
Yeah. And it's the big contention between us and the patent office. Like, it's the thing that we argue about with regard to inventions every single day. They say something's obvious and we try to show how it's not.
Oh, that makes it even more interesting. So yeah, non-obvious. How about you, Rich? What'd you learn today?
Oh, I learned today. Well, I mean, first of all, I learned that the condom in a nut novelty is my favorite invention, and that Roger Comey is my favorite inventor. I kind of hadn't thought of it in those terms, but when you said favorite, it brought it back, and I appreciate you helping me to revisit his memory. So thank you for that.
What an awesome memory too. I appreciate you sharing that. That's great. How do folks get in touch with you and your team, Rich, to learn more?
Yeah, well, you can check out my website. It's goldsteinpatentlaw.com. There are videos there. There's a kind of revamped set of those 6 videos I was telling you about that explain the patent process in about a half an hour. And you could also contact my team to see if it's a match to work together with us. Also, if you want to learn more about patents, I wrote a book for the American Bar Association that explains to entrepreneurs how patents work. It's called the ABA Consumer Guide to Obtaining a Patent. And I mean, this is it. You can pick it up on Amazon, less than $20. And Otis, I also have a podcast called Innovations and Breakthroughs. So if you want to hear stories of people who have gone down this road of pursuing their idea, check out Innovations and Breakthroughs. And that's really it. And I just really appreciate you having me.
Oh, it's been great, Rich. Appreciate your time and sharing with us. It's been a huge lesson learned for me. And those piece of papers that I have down in the man cave, I might dust them off after I read the book, and just see if they're obvious or not. So thanks again, man. And I'm not going to do our walkout because Camden always does that. So I appreciate your time, and thanks for joining us on the Cam and Otis Show.
Absolutely. My pleasure. Thanks for having me.